So, for the introduction to our topic, under the Copyright Law 1987, the topics of immoral, irreligious, seditious, and obscene works have been silent, and this may be due to the fact that the topics are considered taboo in Malaysia, whereas in the Western media, they may see it as an important work or art. So, the possibility of protection is higher. So, the issue present in our topic for today is whether immoral, irreligious, seditious, and obscene works can be protected, and what are the provisions that govern it.
I will start off by explaining the definition of immorality. So, immorality is frequently associated with bad, sinful, or improper behavior. Immorality implies doing actions that are deemed wrong, and it is a state that virtuous people often avoid. So, when someone violates moral standards, he or she does not comply with the generally accepted patterns of behavior associated with social ethics. To further understand about immorality, we may refer to the case of Venice Adatropes against Press Right Holdings, where in this case, the court defined immoral work as works that violate communal ideals or standards. In regards to the copyrightability of immoral works, the Copyright Act 1997 is silent on this matter and there is no specific authority addressing such issue. However, there are indications that Malaysian copyright law does not impose immoral content-based restrictions for copyright protection. According to Section 7.2 of the Copyright Act 1997, works are protected regardless of their quality or their intended use. This section indicates that the Malaysian copyright law does not restrict the copyrightability of immoral works. So as long as the work is the author's original creation and is fixed in a tangible form, it will qualify for copyright protection in Malaysia. In addition, Article 17 of the Berne Convention for the Protection of Literary and Artistic Works expressly states that the provisions of the Berne Convention cannot affect the members' rights to control or prohibit by legislation or regulation the presentation or exhibition of any work in regards to which the competent authority may find it necessary to exercise that right. Pursuant to this article, Malaysia, who is part of the Berne Convention, is given the liberty to control or to limit the exclusive rights of copyright owners in order to protect its public interest. So this means that Malaysia has the right to regulate its own copyright law in regards to immoral work. Despite the recognition of copyright given for immoral work, the enforcement of copyright for this type of work is very questionable. There are two cases that we may refer to further understand regarding the enforcement of copyright for immoral work. The first case is the case of Hyde Park Residence against Yellen. In this case, the court held that enforcing copyright for immoral works by court action would be contrary to the policy of the law. The second case is the case of Lawrence against Smith and Jack. In this case, the plaintiff sought a restraining order to prevent the defendant from selling a pirated version of his work. However, the defendant argued that the book was immoral and should not be protected by copyright. The decision in this case is similar to the earlier case where the judge remarked that because the law does not protect individuals who oppose the scripture, I cannot continue the injunction. Based on these cases, it is evident that the court may deny copyright protection for immoral works. Even though there is no such restriction in our law, courts typically refuse to enforce copyright on this type of work based on considerations of public policy. Next is the effects of enforcement issue for immoral work in the court. The most significant effect is that it would bring injustice to the author of the work because it is very difficult to determine the immorality of a work or the socially acceptable standard in our society. Therefore, it would be unjust to deny the right of an author who does not produce immoral works intentionally. Moreover, the perception of immorality varies from person to person. So this means that the authors will have to be extra cautious, which will prevent them from expressing their idea or creativity to its full potential. Secondly, it would increase the circulation of immorality among the public. Without the protection of copyright, the author has no control over how his work is being used or published. So this means that anyone would have access to the work and may produce multiple copies of the immoral work. Clearly, this goes against the primary purpose of the law, which is to protect the public interest, because if a work is deemed immoral, it should not be spread widely in the public.
Now I will explain about the irreligious work. Copyright was used as a kind of censorship in the early stage of copyright regulation. In Malaysia, the Malaysian Copyright Act of 1987 does not place any limits on written works that are based on religious work. We can look at the case of Television Limited Another versus Viewer Video Sidang Berhad. Federal Court rejected to invalidate the protection given under the Copyright Act, which is not consistent with the Censorship Act in this case. Now we will look at irreligious works in Berne Convention. The Berne Convention's Article 10 addressed several copyright exceptions. This article states about the reproduction by the press and the broadcasting. According to this article, copywriting sensitive or religious work is permitted as long as it does not conflict with existing union rules. It means that the press is not permitted to reproduce material that is irreligious. We can likewise turn to Article 72, although not explicitly stated. Article 70 of the Berne Convention permits members to refuse copyright protection to works for reason of morality or public policy. But the Berne Convention still does not have a particular clause that forbids copyright protection if a work is considered to be irreligious. However, any works that are not consistent with religion can be controlled according to the Censorship Act 2002 in Section 5. This section does not directly mention irreligious work, but it still laid down the prohibition of own, display, or produce any work that contains obscene content, which means that it can be irreligious too. In US, common law demands that work must be innocent. Under the Federal Copyright Statute of US, work that make a significant contribution to the progress of science and useful arts can be copyrighted. Courts in the United Kingdom have established that works that are obscene, sexually immoral, defamatory, blasphemous, irreligious, or seriously deceiving of the public shall be denied copyright protection. Subject matter exclusion based on public policy same averages in United Kingdom. So the lines between irreligious and the public policy exceptions are still blurred. One of the nations that has made its position on works of irreligious work is Canada. It can be seen on Canadian Copyright Act of 1987, which stated no literary, scientific, or artistic work that is immoral, licentious, irreligious, or treasonable or seditious shall be the lawful subject of such registration or copyright. It can be concluded that the majority of nations lacks copyright protection for non-religious works. In Malaysia, we can refer to the Penal Code since it's the statute that codifies the majority of criminal offences and procedures. Section 298A, Clause 1 of the Penal Code states that any form of work, such as a book or a movie that contains words that are not religious, is against the Penal Code. Anyone who creates these works and requests protection may face criminal charges.
So for today, I'll be presenting in regards to seditious work under the copyright law. Firstly, for the definition, there are no specific definitions under the Copyright Act, but we can define it based on other provisions as well as case law. For the Black's Law Dictionary, sedition can be defined as insurrectionary movement tending towards treason, whereas seditious libel can be defined as communication written with intent to incite people to change the government or to advocate to overthrow the government. Furthermore, based on the Sedition Act 1948, under Section 2, seditious can be defined as any act, speech, words, publication, or other object as having a relation towards seditious tendency, whereas seditious tendency can mean the tendency to bring into hatred or contempt or to excite disaffection against any ruler or against any government. Now, moving on, to define seditious works further, we can base it on the case of Melan bin Abdullah and another against PP, whereas the Ong Chief Justice had said he had widened the definition of seditious tendency by making virtually taboo any topics of public discussion calling in question the provisions of Part 3 or Articles 152, 153, and 181 of the Federal Constitution after the 1970 amendments made on the Sedition Act 1940. So moving on to the provisions for seditious work. The Copyright Act is silent in this matter, so it means that there are no provisions in the Copyright Act that says that seditious works cannot be copyrighted. But the only issue here is that the seditious works will be restricted by the Sedition Act 1948, which had been amended in 2015. Now, for the cases on seditious works, there can be two cases that we can refer to, which is firstly the case of Zulkifli bin S.M. Anwar ul Haq and another, and Ari Krishna Aparao and others. So for this case, it is in regards to the seizure of 66 books and collage that contain seditious works. So it was held that the opinion made by the officer were valid and the arrest was justified because from his actions of flipping through the book, he found that the contents of it were seditious. Now moving on to the case of Sadi and Sherwood. This is a case of Robert Sadi's Wat Tyler being illegally copied. So, the equity judges were vigilant to reject injunctions against the pirating of books that might be viewed as seditious. So, it was held that seditious works could not be given protection of copyright under the common law. Now moving on to the scope of seditious works. There are mainly two scopes that can be derived from the seditious works. Firstly, under the Sedition Amendment Act 2015, in illustration of the amendment of Section 3, if A excites a person or a group of persons to demand for the secession of State B from Malaysia, such an act is counted as seditious. Whereas in paragraph E of this section, seditious will also include works that promote feelings of ill will, hostility, or hatred between persons or groups of persons on the grounds of religion. Now moving on to seditious offences. This can be categorized under two parts. Firstly, under Section 4.1a of the Sedition Amendment Act 2015, any person who does or attempts to do any works or publishes or sells with seditious tendency shall be liable for imprisonment of a term not less than 5 years but not exceeding 20 years. Whereas, under the Penal Code, it has been listed under Chapter 6 of the Penal Code under Section 124d. If anyone has been found guilty of printing or publishing, will be sentenced to a maximum of 15 years in prison provided that they did it with the knowledge that it will give a negative impact on the society. Now, to compare it with other countries, we will compare it with Hong Kong. So, Hong Kong had a recent case on seditious publications where 6 current and past employees of the local news organization, Stan News, were detained by Hong Kong police on Wednesday on colonial-era allegations of seditious publications. So, 200 police were sent out to search for the publication office as well as detain the current and past employees of the local news organization. So, this shows that Hong Kong also implements laws on sedition. So last but not least is the question of whether or not seditious works can be copyrighted. So according to the Copyright Act 1987, for a work to be copyrighted, it must fulfill 3 elements, which are originality, fixation, and qualifications for copyright. So the situation here is that there is nothing in the Copyright Act that will restrict the copyright of seditious work because the Act is silent on the matter. So under Article 8 of the Sedition Amendment Act 2015, in subsection 1A to C, if a prosecutor can prove to the court that the work is seditious, the court can prohibit the making and circulation of seditious works. So there are no specific provisions that will stop seditious works from being copyrighted under the Copyright Act 1987, but it is the Sedition Act that will restrict the creation and distribution of the works.
Moving on is to obscene work. Obscene work has not been defined specifically under Copyright Act 1987 and even under Communication and Multimedia Act 1998. However, obscene work generally has been defined as a medium that is capable to deprive one person's mind and to corrupt people's mind as well. Furthermore, I will be explaining with regard to the issue whether Malaysia protects obscene work under Copyright Act 1987. Together with that, we will see a comparison with other jurisdictions, namely United States. In Malaysia, when it comes to obscene work, does not express provision stating that such work is protected even under Copyright Act 1987. This is because Malaysia views obscene work as a taboo. It can be clearly seen from Section 292, subsection A of the Penal Code, where it makes it as an offence for a person to sell, to hire, to distribute, to circulate, or even to have possession of any obscene book, pamphlet, drawing, painting, representation of any figure and whatsoever. From here, it can be clearly deduced that in Malaysia, when it comes to obscene work, even though it falls under works that are eligible to be copyrighted, but still, it is an offence under the Penal Code. Next is the comparison with other jurisdictions, namely United States, and how United States view obscene work. Obscene work in United States, under its own constitutional law, allows authors to protect their original expression of ideas in order to be advanced in science and useful arts. This means that even though an art contains any obscene material, it can still be copyrightable. A clear example can be seen from the case of Francisco, where the painting that was created by the author is one of the sexiest paintings. However, now it is hanging on the most prestigious museum in Spain. It is different to compare with how Malaysia views obscene work, and we can simply draw an example from the Francisco itself. What if Francisco is created in Malaysia instead? Clearly, the author will be penalized under Section 292A of the Penal Code. However, in United States, there is a different approach when it comes to obscene work. They viewed it as an expression of idea of the author. So, as long as this element, originality of expression of idea, is present, the author is allowed to protect their creation. In conclusion, as a result of the cultural differences in Malaysia and in United States, each country has their own approach and justification for recognizing obscene work as copyrightable.
Conclusion, authors should refrain from producing works that are widely viewed as immoral, obscene, irreligious, or seditious. Even if there is no specific authority which restricts the copyrightability of this type of works, it is possible that the owner of the work will not benefit from their work. This is because courts often refuse to grant injunction to restrict the publication of unauthorized version of these works due to enforcement issues of copyright for this type of work. Additionally, it would also attract criminal liability on the part of the author. Moreover, the creation of such a work would negatively impact the public interest. Since the enforcement of copyright in such a work is highly questionable, there is a high probability that it will be widely distributed on media platforms. This is because no one controls the work, therefore the publication of such a work would not constitute an infringement of copyright. Therefore, for the advantage of the authors themselves, it is preferable to avoid creating this type of works in order to gain the full benefit of their effort.